is correct.
Thank you. Can I just go back to some of the evidence you gave earlier? I just want to clear something up. You've mentioned that you did meet with PERC as part of the discussion we had about meetings with the family and Crown Office, and there was a discussion about meeting with PERC. I had suggested to you we've heard evidence about one meeting where the meeting with the family was with Kate Frame, who was the commissioner at the time. Do you remember when you met with PERC?
I mean, from recollection, it was quite early on.
Right.
I
remember where it was?
I believe it was in the offices of Amar Anwar.
I think we have heard some evidence about a meeting or meetings that have taken place in his offices from investigators from PERC. Were you present at that meeting also?
Well, I was certainly present at one, or potentially two. I mean, aside from the meeting with with Frank McHolland, and then with the Crown Office, but that was at their offices.
All right, thank you. I'd like to move on, please, to go back to 366, if I may, and paragraph 68. Please. There we are. Inquest has documented how there has been an institutionalised unwillingness to approach deaths in custody as potential crimes from the outset, resulting in loss of forensic evidence, identification of witnesses, and ability to probe police officers' accounts of events. I think you've talked about an unwillingness to approach it in that way already today. Families want cases to be dealt with as a disciplinary or criminal investigation from the outset, where it appears on the face of it to have been potential disciplinary or criminal offences. They should be entitled to expect that the correct procedural steps are taken to ensure the integrity of those proceedings in the event that prosecutions or disciplinary proceedings are ultimately brought. And again, from the experience of Inquest, are families interested in not just prosecutions but also in disciplinary processes?
I think the answer to that would be families are wanting accountability where there has been evidence of criminality or wrongdoing, which would include both disciplinary or criminal proceedings, which is why it's so vital that the investigation is conducted properly and that it's robust and that it leaves no stone unturned.
Thank you. And can we look at paragraph 69? When it comes to evaluating the actions of police officers, many bereaved families and clients experience a sense of IOPC bias, that would be the equivalent of PERC, towards the police, particularly where decisions are made from the outset that investigations are not criminal or disciplinary investigations. This perception is in part because some of the IOPC staff are ex-police officers, an issue which is constantly raised by families as being at the heart of their perception of bias and lack of independence. IOPC structural independence from the police is undermined by this lack of cultural independence. And this can be manifested in them taking an overly cautious and conservative approach and a lack of robustness and rigour in decision-making when investigating the actions of police officers who are unable to provide a reasonable explanation for their actions. This has been a long-standing issue and one reflected in the Casale Review Home Affairs Select Committee inquiry into the IPCC 2013 and the Angelini Review. And when you refer to the Angelini Review, is that the 2017 Deaths in Custody?
Yes.
And I'm interested in the inquest's experience of families being concerned about this aspect.
I mean, that's a long-standing concern which exists to this day, and I would suggest within the context of PERC that obviously it's also similar in the sense that the PERC has a lot of ex-police officers within its staff team.
And does that undermine the trust and confidence again that families have?
I think without doubt. I mean, I would say that I think families accept that obviously good investigative skills are crucial, and understanding policies and procedures and things. So clearly there is a need for expertise there. But in terms of the rigour with which investigations are carried out, and the ability and really the willingness and ability to properly probe, I think that's something that has been found wanting in a lot of the investigations that certainly we've been involved in.
And in 607, your second statement, if we look at paragraph 35, I think you specifically address this further. Paragraph 35. For the I Can't Breathe report, we researched the issue and found that none of the post-death investigation processes, and then you list them, the IOPC, the coroner's inquest, prevention of future death reports, the Crown Prosecution Service, meaningfully consider the potential role of racism. We looked at 12 cases of black men that had occurred between 2008 and 2018. We looked at the record of INQUEST, which sets out the findings and conclusions, and not a single record or report mentioned racial discrimination or racism. Only 2 of the cause of inquest and 1 prevention of future death report had the ethnicity of the black men who died at all. Is that a reference to them being black?
Yes, I mean, it was impossible. From the reading of the reports, you would not know the race or ethnicity of the person who died.
Thank you. The result is that the potential role race may have had is entirely absent from the official version of these events. What impact does that have on families?
Well, I mean, the reason we did the research was because, you know, as we've already addressed, this has been a thematic area of concern, and we had some funding to be able to do a more deep dive into our work, and we had been increasingly concerned that, in our view, a lot of these deaths raise serious questions about racial stereotyping of people who died, and yet that was completely absent from the investigation and inquest process, in fact, all of the processes. And in order to be able to do a report, to make recommendations, clearly we needed to properly evidence that. So there was a significant amount of research that went into looking at those cases in detail. We also had a reference group of lawyers who were interviewed, who'd done this work. And also families were interviewed. And of course, what families said was, well, you know, of course that was in our minds, but we didn't feel confident in raising this as an issue because we were worried we'd be accused of, you know, playing the race card, or we'd already experienced hostility and suspicion, and this would make us feel, you know, this would potentially make us be seen as more difficult. And so there was that disconnect between what families thought and then what was how the investigations were approaching this. And I mean, it's interesting to note that in one of the cases that I've referenced in the report, you know, even a coroner accepted in the death of Olusheni Lewis, the coroner herself, who had not examined the question of race during the course of the inquest, herself acknowledged that race was the elephant in the room. And so the reason we did the research was really to try and evidence the fact that, you know, we felt that race and the question of racial stereotyping and racism should be part and parcel of any investigation that was carried out into the death of somebody from a black or racialized community.
And it should automatically be part of that investigation.
Yes, absolutely.
And I think then you do say at 36, that renders race and racism invisible. If you don't acknowledge something as a problem, as an issue, how can you develop policy interventions and how can you ensure that the issue is addressed? And so is that you consider that without even asking questions about that or addressing that or exploring that line, you can't then identify and acknowledge where that issue is a problem.
That's right, and I think, you know, the other observation I'd make is that I think there has been a kind of institutional denial of racism and of the disproportionality that the report demonstrates. And so we felt that this was something that, you know, if we produced a report that we could then use in our policy work and use in our meetings with the various investigation and oversight bodies. And I mean, I was also pleased to see that, you know, obviously we gave evidence, as you've mentioned earlier, about the evidence we gave to the United Nations in their inquiry into law enforcement and people of African descent. And they made a very clear recommendation, and obviously it's, you know, this is globally, but they made a very clear recommendation about the importance of examining the role that racial discrimination, stereotypes and biases may play in law enforcement and accountability processes. And I was pleased to see that because in a way that, you know, absolutely captured for us the essence of what we were trying to do with this report to ensure that it was investigated.
Thank you. And talking about the United Nations, could we go back to WIT 87, please, and look at paragraph 59? These we've looked at earlier today. These are the 2020 submissions to the United Nations. And we see here you've also submitted in relation to prosecutions. Our monitoring shows that since 1990, that there have been 9 unlawful killing conclusions returned by juries at inquests into deaths involving the police, and 1 unlawful killing finding recorded by a public inquiry into a police shooting, as well as other findings critical of force used. Yet none of these have resulted in a successful murder or manslaughter prosecution. Indeed, we are not aware of a single occasion when the police have been successfully prosecuted for manslaughter at an individual or corporate level. And I'm interested in this comment. Was this more research that INQUEST did?
I mean, this is something that we do as a matter of course. We monitor INQUEST outcomes from our work, and then what happens to them. Just bear in mind, this was December 2020, and since then there was the successful prosecution of a police officer following the death of Dalian Atkinson, which is in one of my subsequent statements. But I mean, absolutely. And I mean, I think, you know, it's one of the reasons why we've talked about kind of, you know, immunity and impunity within the system, because even where there has been the most overwhelming evidence of dangerous or excessive use of force, and juries have reached conclusions which were then on the criminal standard of proof, we've then not seen corresponding action, you know, either criminal or indeed, in many cases, disciplinary.
I see.
And I think just to add to that, and you know, going back to what that does to families' confidence, I mean, it's fair to say, I think that, you know, this is an issue that has really undermined both family confidence, but also community confidence in the processes that we have for holding the police to account. Because on paper, you know, we have a relatively sophisticated framework, but in reality, the question as to, you know, whether or not it's achieving accountability and change is something that is not borne out by a lot of the work. And in fact, you know, it's very often families engaging in campaigning that really draw these issues to public and parliamentary attention. And I think, you know, utilising the United Nations was important to us, because we were, you know, able to use our experience in the UK to help try and develop best practice, you know, globally.
I was going to come on to the issue of misconduct proceedings, actually. You've obviously explained the situation regarding prosecutions, but am I correct to understand your evidence that you've also seen a failure or a lack of misconduct proceedings being taken against officers, even where there have been findings of unlawful
Yes.
killing or excessive force having been used?
Yes.
And are you aware from your experience why there are no subsequent misconduct proceedings?
I mean, I've I've said earlier on that there are lawyers who could probably better answer that question, but certainly, you know, the other issue that we've seen is officers, you know, retiring or leaving the force before action can be taken, and you can only imagine what that does to families, but also just the way in which these processes are just so long and drawn out that I think, you know, the lack of rigour which I've talked about previously in regard to the investigations is also subsequently revealed through the lack of the misconduct processes.
We've heard some evidence about the impact of a retirement or officers leaving before misconduct proceedings can be concluded. Is that the position in England and Wales, that officers can retire or leave before misconduct proceedings are concluded?
It certainly was. My understanding is that the system has been changed now. So, but I think one of the concerns that certainly families have had is that even when these processes, you know, are ongoing, that the sanctions at the end are very often what are called words of advice, and it's very rare to see police officers sacked as a direct result of, certainly in the context of deaths in custody.
And can I ask you, where an institution such as a police service, police force, or Crown Office in Scotland have been found to be institutionally racist or have admitted that they are institutionally racist, I'm wondering on whether you have any concerns about those organisations considering issues of conduct in relation to staff themselves. Obviously, I'm considering the question of independence. And I wondered if you have any concerns about that matter.
Yes, and my understanding, can you just explain the question again?
Yes, sorry, my fault.
No.
We've heard evidence
Yeah.
that Police Scotland's Chief Constable
Yes,
last year admitted the Police Scotland were institutionally racist. We've also heard evidence that as a result of a report, the Jandu report, and incidents in relation to Chokar and the murder of Mr. Chokar, that Crown Office at that time were considered institutionally racist. And I'm interested from the perspective of considering conduct and misconduct matters, to what extent INQUEST or yourself have any concerns about organisations which have admitted or been found to be institutionally racist are in charge of looking at conduct issues for their staff?
I mean, I think the short answer is yes. And of course, you know, there is expert evidence that could be adduced to assist in that role.
Where would that be from?
Well, from, I mean, people who, I mean, I think there's a systemic problem about how organisations, and I'm thinking about the IOPC as it now is, in terms of their own ability to investigate race and racism, and the fact that there are people who, you know, there are plenty of academics who've written, you know, extremely important research around, you know, how racism, be that, you know, institutional, systemic, structural, manifests itself, and who would be in a good position to be able to offer expert advice about how one investigates that. And I think if you look at the Sylvia Casali reinvestigation into the death of Sean Rigg, I thought that could and should have been a bit of a turning point for the IPCC, because she was very clear in that investigation, that reinvestigation, how the question of race just simply wasn't looked at, and that could have been a really important learning opportunity for that that organisation, but one, in my view, that they failed to grasp. So I would say, of course, there is a problem about, if you're an organisation that, I welcome the fact that the Chief Constable actually came and gave evidence to that effect, because certainly that's not something that has been repeated in England and Wales, not least with the Metropolitan Police Commissioner. And so I think that's an important step forward, but it's all very well accepting that it's a question of how does that then change culture and practice within the institution itself. And I would suggest that if you're really, really committed to cultural and practice change, then you need to also get help in helping to drive that by people who understand what we mean by institutional racism and structural racism, and how that impacts on the way in which police officers behave at an individual, but also at a corporate level.
And would INQUEST see a role in specifically in Article 2 cases where there have been deaths of black men in particular, in relation to considering issues of the conduct of officers in a situation along those lines? Would INQUEST see a role for perhaps an independent investigation into things like misconduct?
Yes.
Can I ask you to, we've been talking about post-incident management and issues regarding that. Can I ask you to look at paragraph 90 of your first statement, which is the 366 statement, paragraph 90. Now this covers 3 pages, and I don't intend to go through every single line, but this section sets out in some detail what, as I understand it, INQUEST would consider to secure a meaningful investigation. Yeah. And it reflects what families would be looking for, is that fair?
I would suggest it reflects what families, INQUEST and the lawyers that we've worked with over these decades have sought to try and achieve from these from these processes.
Thank you. And can we move on to D, first of all, which is the 4th, yes. To be trusted to receive information on a confidential basis so that matters can be shared with them as the investigation progresses, and key documents such as body-worn footage, CCTV can be disclosed. Many families are told that disclosure of key materials cannot be provided, although no family member is witness to the events covered by the investigation, simply because there is the potential for a criminal process, and many families have to battle to receive disclosure throughout the process. Could you expand on why this is one of your suggestions for best practice?
I mean, because I think that one of the worst things for a family is the kind of drip feed of information that they get as part of the investigation, not least when it takes a long time, and that there are processes that can be put in place so that they can actually have some of those documents, respecting the fact that that there is confidentiality, and it's important, and that I think families, if families have information explained to them, then they are perfectly able to understand the need for confidentiality, for the fact that this is information that will be shared with them, on the understanding that it is that, it is being seen by them alone and that they can't talk about it. And many of the families, that I work with, that happens to. But I think it's important to feel, if you want to feel part of a process, that you're given access to that information. And too many families have to actually, fight for that information as the investigation goes on. And, I'd suggest that, if a family are properly legally represented, then their lawyer can help guide that process and, ensure that, footage is seen within their offices and, it's not shared, etc. So, but it's terribly important because I think, for many people, as I said, the worst thing has happened, and not having that information, it creates a lot of trauma, and it can actually assist them to begin to understand what happened, but also respect the integrity of the investigation that is being carried out.
And again, does that help to build trust and confidence?
Yes, absolutely.
And you then say, many families have to battle to receive disclosure. We heard evidence from Professor Meir, and he talked about families having to litigate or do FOI requests or that type of thing. Is that, do INQUEST have experience of that when you say battle to receive disclosure?
I suppose unfortunately for many families it does feel like a battle, and it feels like a very unequal playing field when, you're a bereaved family and you have your lawyer and, we only really need to look around this inquiry room to get a sense of the interested parties that often are involved when these deaths happen. And so, it's quite often the drip feed of information or families at the outset giving very important information to the investigators, and then for whatever reason, that information not being seized, like important CCTV footage. We've talked about, body-worn footage, which is obviously more relevant down south. But, and I think, families with a lawyer struggle, so goodness knows what it's like for a family who don't have access to legal representation.
Thank you. Could we look at F now, please? Cases to be dealt with as a disciplinary or criminal investigation from the outset, where there appear on the face of it to have been potential disciplinary or criminal offences, and that the relevant procedural safeguards are put in place to ensure the integrity of the investigation overall. Families feel strongly that a level playing field requires police officers to be treated as a civilian would if there are grounds to suspect that they have been responsible for a crime, or as they would be treated in a place of work if there were potential serious misconduct. And they naturally compare the process with how a civilian would be treated. Again, is this a theme that you have become aware of through the work with INQUEST?
Yes.
About the reaction of families?
Yes.
And is there, I think you said earlier that there may be a perception, if I can summarise it this way, that police officers are giving preferential treatment?
Yeah, and that they're above the law. That's how it's perceived, and going back to the earlier observation about what happens from these processes, it's also borne out in the reality in terms of the lack of prosecutions or indeed lack of disciplinary action.
Thank you. And although the Chair will be able to read all these items, I'd just like to now turn to G for golf, now the seventh one, which begins independent investigations, and coroners should ensure they meaningfully consider the role and impact of race, ethnicity of any black and or racialised person who dies following police contact, examining the potential role of racism or discrimination from the outset, including in the terms of reference and through to the scope of the inquest and inquiry. And I think you've said that already, that you would like to see that automatically included, particularly where there's been a death of a black man.
Yes.
Thank you. Could I ask you some questions about family liaison officers now? If we go back to your original statement, the 366, and if we could start at paragraph 39. Now, you've given a significantly detailed explanation in relation to FLOs, and I won't go through every line, but I'll dip into some of this if I may. I think in 39, when that's on the screen, halfway down, you say this role has not translated well. Do you see that?
Yes.
For those families who have been bereaved following police contact, alongside their support role, the FLO is also an investigator and an evidence gatherer. Families are not always aware of this, and so tensions can arise when families perceive a lack of transparency. The FLO role is often confusing and at worst intrusive. Could you help the Chair understand some of the difficulties that families who INQUEST have been supporting, some of the difficulties they've experienced?
I mean, I think I say earlier on that, you know, the flow role is well established to support victims of crime. And of course, I think, you know, it's important to say here that the families that we work with are not seen as victims of crime. And that has a number, that results in a number of issues, not least they're not, they don't get the provisions of, for example, victim support or for automatic counselling, etc. And the flow role it has, when I say it's not translated well, it's particularly around the investigation and evidence gathering role that they perform along with the investigation body, be that the IOPC, IPCC, or indeed the PERC. And, you know, what families have reported, and I think I might have given some quotes somewhere about this, is that they have felt that they are the subject of investigation, and that the flow has been trying to get information from them about their loved one to report back to the investigation, rather than the way that sometimes the flow role is presented, which is there to advise and support. And I think that causes real tension. And families have reported being felt like they were being spied upon, and I think, you know, that's a real perception. And however good the flow may be, at the end of the day, they are part of the investigation process. They are not there to carry out an independent role in terms of, you know, the family's advice and support person. And, you know, and I distinguish that between the role of the flow in other situations where that role can be extremely helpful for families when they've had experienced a death, or so it is about the fact that at the end of the day the flow is part and parcel of the investigation that's being carried out.
And so is this a particular difficulty in situations where there's been a death following police contact, where it's an Article 2 situation?
I'm talking about the role of the flow following deaths in custody and Article 2 cases, absolutely.
Thank you. And then if we turn to paragraph 46, please. You also mention and I'm halfway down this paragraph, they also need to understand and recognise family dynamics, and that often the responsibility for informing other family members on progress falls to an individual. I'm interested in that aspect, this idea that it can fall to an individual. What pressure does that put on that individual member?
I mean, it's I think it's extremely difficult to be in the situation where you are the, I suppose, the go-to family member who has to report on progress of, you know, investigations, inquests, whatever it might be, at a time when you're also trying to navigate the processes yourself. I mean, the emotional toll is absolutely huge, and I think that it places just a lot of pressure on people, and I mean, I've seen it. I've seen it for 30 years. On, you know, it's that it's very often there will be individual family members who have effectively kind of drive those processes for the benefit of all family members, and it takes a toll. And that's not least the fact that, you know, quite often they've had to actually, you know, fight to understand what their rights in that process are. And, you know, I've already described the kind of information deficit that often follows these deaths and how difficult it is to get access to advice and support.
Thank you. And again, I'd like to move to the best practice section of this statement. And this is at paragraph 52, sorry. There we are. And it says, the following is a summary of the key points of best practice in respect of flows. And again, is this gathered together from experience from INQUEST,
Yes.
comments from families and lawyers who are
Yes.
involved? So you talk about A, clarity from the outset, B, signposting to independent advice and support, C, all families should be advised of their rights to legal advice and representation. You talk about, at the bottom of the page, written and oral information about support services being provided to families. And then D, refer the family to INQUEST at the earliest opportunity. E is training from a trauma-informed approach. And F, clear protocols for the structure of the relationship. And G, bereaved people should be treated with dignity and respect, empathy and compassion, and the consideration that any bereaved person should expect. This, tell me if you disagree, this seems to mirror some of the comments made by Macpherson in the Stephen Lawrence inquiry. We've heard evidence about bereaved people should be treated with dignity and compassion and respect.
And I mean, it's also, I think, spelled out, you know, very clearly in the Angelini review. And just while you were saying that, I was just thinking that your earlier point about the responsibility lying on one individual. I think the other issue is that, you know, because these investigation processes, as we know, are protracted, families wait for, you know, they're told that on certain dates information will be forthcoming, that decisions will be made. And so families wait for those phone calls or for that information to come. And I don't think people realise what it's like if that phone doesn't ring or if that information is not forthcoming, and how that makes people feel, not least if you are the person who everybody else is relying on to explain what is happening. And I say that because I remember a conversation we had with the DPP, the Crown Prosecution Service, about this, and trying to get them to understand that, you know, if you agree to give families an update, you give them an update regardless as if there's nothing to report.
Right.
Sorry, that was a clumsy sentence. But you
make contact.
You
with
make
the
contact
family
regardless. Because otherwise families are just waiting, you know, bereft of information, and it's better just to have that contact even if there's nothing to say.
Yeah. All right. And you mentioned the word recommendations. As I understand your statements, without taking you to any particular passages, you take the view that there are issues about recommendations of reports and things that maybe are not being done. And I think at part of your second statement, 607, if we could go back to that, you talk about the national oversight mechanism. And I'd like to move on to that, please, and ask you some questions about that. So paragraphs 147 and 148. Sorry, I've maybe...
Yep.
Well, we could start with 147. The lack of a statutory duty of candour is also relevant, and you talk about the Hillsborough law.
Yeah.
And it's so important it applies to all law enforcement agencies. But actually, it was the national oversight mechanism that I was coming on to, and that's 148.
Yeah.
And if we can look at that, please. I am asked to explain why INQUEST are campaigning for the introduction of a national oversight mechanism. to monitor the implementation of recommendations arising from deaths involving the state. 149, prior to coming up with this proposal for an independent body to be set up, we met with bereaved families, lawyers, civil society, academics, policy experts, and oversight and monitoring bodies. And we also met with the Independent Advisory Panel on Deaths in Custody, of which I was a member. Was that the cross-party
That's the
panel?
cross-government sponsored.
Right.
Yeah.
Now, I wonder if you could assist the Chair by perhaps explaining a little about the context here, how this suggestion arose.
Yeah. I mean, maybe I'll start just by talking about it in the context of restraint-related deaths, just by way of example, because what your inquiry will have realised, not least by some of the information that INQUEST have provided and others, is that this is not an under-researched area. There have been investigations, inquests, independent government-commissioned reviews, academic research, etc., all making successive recommendations about action that could be taken to try and affect policy and practice change. And I think, for me, one of the biggest frustrations about INQUEST work is seeing the same issues being repeated across our work, both in the context of deaths in custody and detention, but also even if you're looking at other areas like Hillsborough, Grenfell, the infected blood inquiry, where we have seen recommendations made, and you always see the state's organisations saying that lessons will be learned, that action will be taken. And what has become very clear is that there is no independent body that is responsible for monitoring, analysing and following up on action that has been taken. So it's very often families who have been the drivers for change following their loved one's death, or following inquests, or indeed something like the Angelini review, which we can come on to. And I think what happens is that too often the recommendations, which potentially are life-saving recommendations, that's the whole point of them, they are about preventing deaths happening in the future. You will sometimes see some initial work and initiatives and a commitment by some people, but of course people move on, and organisations do not have good memories, good knowledge. And so what tends to happen is that the deaths, the recommendations following deaths just disappear into the ether, or sit on a shelf and then only come out when maybe a parliamentarian asks a difficult question. And so our proposal is about trying to ensure that there is that proper oversight of recommendations, which we see as being important for anybody concerned with state-related deaths and their investigation, and importantly their prevention.
So filling that black hole where recommendations are made, but then no body working out, as you say, monitoring, analysing or following up recommendations, those recommendations designed to prevent deaths in the future.
Yeah, and I mean, I think just to add to that, I think there's also a really important human rights case for establishing this, because we've talked about Article 2. Well, the Article 2 obligation is not just to investigate, but it's about learning lessons for the future. And I recently gave evidence to a House of Lords inquiry into the Inquiries Act, and I know members of the House of Lords were quite shocked to discover that this doesn't actually exist. And in the context of inquests, but also public inquiries, you may have a parliamentary committee that might look at one aspect of a public inquiry, but that's not sustained. And I think one of the really important things about an independent oversight mechanism is to make sure that there is a constant following up and reviewing of what action is actually being taken, on the ground, so that there is a much more rigorous process to ensure that, these recommendations that have come out of inquiries, often when the worst possible thing has happened, or have come out of inquiries because of serious concerns about the conduct of government or government organisations, that there is a real opportunity to learn and to maximise that preventative potential that inquiries, inquests, fatal accident inquiries can actually perform.
Thank you. Can I move on to something else now? We looked earlier at I Can't Breathe, the report, and that was SBPI 607. Oh, sorry, that's your, if we look at your statement, first of all, 607, and we look at paragraph 27. And you say here, we recently produced an evidence-based report called I Can't Breathe. On paper, England and Wales have a highly developed system of oversight of police conduct, with provision for identifying racism and a well-established investigation and coronial system to examine the circumstances of deaths in state custody for the state to be accountable. However, we were aware that the lethal pattern of disproportionality continues, and that no death of a black person following police custody or contact has led to officers being effectively disciplined for racism or held to account. And that's subject to the comment you made about Mr. Atkinson's death and the criminal trial that resulted. This was also despite the recommendation in the Angelini review that the police watchdog investigators should consider if discriminatory attitudes have played a part in all cases where restraint, ethnicity and mental health play a part. One of the things that we had documented in our work was how race was the elephant in the room. It was invisibilised, erased from the official narratives about the death, because it was never investigated as part of the investigations that followed the deaths or through the inquest hearing.
Correct.
And I'd like to look at the next paragraph 38, and this contains your recommendations for I Can't Breathe. Now, I would plan to simply go through your statement on this, although we do also have the report itself at 513, if you feel that would be inappropriate to use your statement.
They would just cut and paste
I
it
can
from
use
one
the statement.
to the
Thank
other,
you so much. So let's look at paragraph 38. The other recommendations in the I Can't Breathe report are as follows. Post-death investigations and scrutiny. A, the IOPC and the Coroner's Service should ensure they meaningfully consider the impact of the race, ethnicity of any black or racialised person who dies following police contact, examining the potential role of racism or discrimination, and it should be integral and a proactive part of their work. And this in turn should be central to the work of the Crown Prosecution Service in their response to these deaths. And so again, does this follow on from what you said earlier about it should essentially be automatically included as part of a proper investigation, an adequate investigation into deaths in custody?
Yes.
Thank you. And then if we can move on, please. B, the IOPC should amend their guidelines and practice for handling investigations into racial discrimination to bring them into line with the way allegations of racial discrimination are approached in civil courts. This means explicitly incorporating a shifting burden of proof set out in the Equality Act 2010 and ensuring this guidance is properly applied through specific training of IOPC investigators. And would this be equally equivalent to PERC investigators? And so an alignment, if you like, between the civil approach and an approach taken in relation to actual criminal investigations.
And this is the matter that, I mean, this, I think I said this earlier, but this was a report that also engaged with, I believe, 12 of our INQUEST lawyers group members who've got particular expertise in working around these cases, and so, you know, and also had experience with the Equality Act.
Thank you. C, the Chief Coroner should develop detailed guidance and training on how coroners should approach investigating racial discrimination in inquests to fully reflect Article 2 and the Equality Act. And B, in the context of Scotland, these recommendations and the findings of this report more broadly should be considered by PERC, the Crown Office, and in relation to fatal accident inquiries. Then inspectorate and monitoring bodies, if we can move up the page. Consideration of the impact of race and racism on the treatment of people in police custody and contact should be central to the continued work of monitoring and inspectorate bodies such as the UK National Preventive Mechanism, His Majesty's Inspectorate of Constabulary and Fire and Rescue Services, and independent custody visitors. And then the treatment of black people by the police. One of the recommendations was to call on the UK Government, the Home Office and National Police Forces to make a time-bound public commitment to end the deaths, the disproportionate use of force and broader ill-treatment of black people in police contact. And this commitment should include the following recommendations around restraint and mental health.
Yep.
Sorry. Yes. Sorry, I lost my place there. I think there was one called Restraint, yes. We call on the Government to implement the unfulfilled recommendations of the Angelini Review from 2017, the deaths in custody, with a particular focus on recommendations relating to the use of force and restraint. You mentioned mental health. And you talk about, specifically about de-escalation and care being the focus. In the long term, the UK Government should urgently review national and international evidence on alternatives to policing in responding to people in mental health crisis, with an aim of creating nationally available systems which put community services and specialist healthcare practitioners at the centre of crises responses without police. And then keep going, you then turn to data. And here you talk of the IOPC to monitor and publish data on restraint-related deaths, both in police custody and deaths following police contact, disaggregated by ethnicity and other protected characteristics. And following on from that, you deal with duty of candour. We've heard some evidence about that, and we understand there's a bill going through the Scottish Parliament in relation to matters connected with that and other issues. Access to justice. The Government, Coroner Service and IOPC should enact the outstanding recommendations of the Angelini Review around family support and the coronial system. National oversight mechanism. So this is a specific recommendation regarding what you've just explained to the Chair, that the Government should establish a new and independent body tasked with the duty to collate, analyse and monitor learning and implementation arising out of investigations and inquiries. Transformative social change. To decrease reliance on policing and investment in the criminal justice system. And then in your inquiry, you then talk about specific comparisons with Scotland and England. I only have one or two minor matters to deal with, but I'm conscious that the time is drawing to when we normally have a break. But I think I've got one issue I could perhaps deal with now. And this relates to publications for families. And I wonder if you could look please for me at SBPI 00515, which I understand is a guidance document. 00515. Achieving Racial Justice at Inquest, a Practitioner's Guide. Am I right in saying this is a document which provides guidance that INQUEST have prepared along with Justice.
Yeah, the human rights charity Justice. They approached us a while back when we were doing our research into the report I Can't Breathe, and they were interested in looking at this issue in more detail. So a working group was set up, chaired by one of our inquest lawyers, Leslie Thomas, KC. The working group included lawyers representing the state, as well as family lawyers, academics, family member, and obviously INQUEST and Justice. And it was very much, it's very much, I think, best described as a bit of a toolkit for those conducting investigations, inquests, and I would argue its relevance, of course, in Scotland. And I was very pleased that we got the active support and support of the Chief Coroner's Office in doing this, and we're already seeing that it's having an impact in the way in which some investigations are being conducted. But so I think it's really very much a kind of blueprint of good practice. And the idea behind it was that it provides not only the broader context on why it is we should be looking at this issue in a broader context, it's also kind of gives everybody involved, you know, whoever they are, investigators, coroners, and a kind of an opportunity to get a sense of how and why they might approach these issues within investigations.
So who gets these documents or brochures, guidance? Who gets this?
It's a report,
It's a report.
effectively. So, I mean, we had a launch of it. We've disseminated it. Well, INQUEST and Justice have disseminated it, and we're hoping that the Chief Coroner will consider in their next round of training for coroners, mandatory training for coroners, that they will have a session on the report during that training. But it's very much up to us to try and, you know, drive that change. But I think it's a helpful document for people.
And does this help those working within at least the coronial system, if not further beyond, to understand perhaps steps that can be taken during that investigation, that part of the process?
It's for anybody.
regarding race?
Sorry to cut
No,
across
no,
you.
not at all.
It's for anybody who's involved in investigations and inquests. I mean, I would say it has a relevance across the UK and more broadly, to be perfectly honest. I mean, that was the point behind it. It was to assist people in their roles.
Thank you. I'm conscious that it's now 3 o'clock. Would that be an appropriate time?
We'll take a 15-minute break. Ms. Graham.
Thank you. I'd like to now turn on your second statement to paragraph 116. And this deals with the final matter that I'd like to address with you today. So this is SPPI 00607, and it's paragraph 116 towards the end. You'll see that this is under a topic called restraint.
Yeah.
And if I can read from the third line, a pattern that we've seen time and again. Do you see that? Line 3 at the end, a pattern that we've seen time and again. You got that there? I think it's really evident, and looking at Sheku's death, is that default of police officers to a situation is to go in and restrain and use force, whether that is the use of batons, CS spray or hands-on restraint, rather than stepping back, de-escalation, containing. That response aggravates and exacerbates the situation. It increases the risk of harm to that individual because somebody who is in a state of agitation is often very scared, very frightened, and so a rational response to fear and to restriction of oxygen is to struggle to breathe. The mechanics of a restraint death is such that that can be fatal. There is a video called 60 Seconds to Save a Life, which was published precisely to address how fatal restraint can be. Now, am I understanding correctly that after the Angelini death in custody report in 2017, there was a concern expressed in relation to some of the findings?
Yes.
And a decision was taken to launch a video to help police officers recognise a medical emergency in custody and act quickly to resolve it. Is that correct?
Yes, I think the video, though, was to show precisely how quickly restraint can become a medical emergency and actually how quickly somebody can actually die. That was the thinking behind it.
Do you remember the bodies that were involved in preparing this video?
From recollection, it was a bit difficult to actually find because it was on YouTube. But I believe at the time it was the College of Policing and the National Police Chiefs Council who were behind the making of the video.
And they combined and created this video to provide assistance to police officers, perhaps to be used for training purposes.
Yes.
I would like to play this video. Now it's very brief. It's a minute, a minute and a few seconds, and I would like to play that if that is possible. And what we'll do is we'll watch it, and then I'll ask you one or two questions.
60 seconds to save a life. Whether you have made an arrest and the use of restraint has been unavoidable, or you are in custody and a violent prisoner under restraint has been brought in, stop. Take a minute to think. Anyone under restraint is at risk. Is the detainee displaying any red flag symptoms? Is there anything apparent that is raising the risk? Now it's time for you to decide. Is the detainee a prisoner or a patient? If you decide they are a patient, declare a medical emergency. Call an ambulance immediately. Consider the consequences of not taking the time to think. Take the time.
Oh.
And so, was this a video that, from INQUEST's perspective, you'd like to see that type of training being given to police officers to emphasise the speed at which restraint we've heard is a risk, there can be a risk of death, but is that the type of thing that you'd like to see in terms of emphasising the speed at which these things can occur?
Yes, I mean, I guess, you know, a frustration is that we've had various initiatives previously. I mean, I recall, and again, it's in my statement, following the death of Roger Sylvester, who was a black man who died following restraint, there was a review by the Metropolitan Police, and then there was guidance and kind of warnings about the dangers of positional asphyxia, particularly about the dangers of prone restraint. And I think, I'd be very interested to know how many new police officers have seen this particular video. And I think it goes back to my earlier point about, initiatives that follow high-profile deaths, which of course I welcome. But, how do we ensure that this information is actually embodied in policy and practice on the ground? And how do we ensure that where restraint's taking place, that where there is body-worn footage, for example, that senior police officers are actually reviewing that to check how restraint is being carried out? I know in the Angelini review we made recommendations about training involving bereaved people, and certainly myself and in fact Marcia Rigg, who you're hearing from, but also the family of James Herbert, we've addressed various police conferences about our work, but also about the concerns that led to the deaths of their relatives. And I know from the police officers involved how important that was to hear that perspective. And it was I think a way of actually talking about these issues in a way that people could identify with the family member before them, who was there because they wanted to try and not only explain the personal impact of having a relative die in those circumstances, but about trying to help people understand the risks and how change, how to drive the change that they wanted to see as a result of this. But as I say, I mean, I've done this work for a very long time, and sadly what I see is that positive initiatives often just get forgotten because there isn't that kind of institutional knowledge.
We've heard some evidence about institutional memory loss when
Yes.
people, as you said before the break, leave a role, move on, get promoted, and that can the impetus, the drive forward can be left.
And I have to acknowledge the vital contribution that families have played to trying to drive that change. Often putting their own lives on hold because they're so committed to try and see things changing so that other people don't end up in the same situation that they have. And in fact, one can argue that in individual prosecutions in these cases, might be one form of accountability, but for families, another form of justice and accountability is to actually see things change so that other people don't die in similar circumstances. And as I said in my earlier evidence, this is not an area that has been under-researched. There are numerous documents and guidance and recommendations about the dangers of restraint, and the fact that we're still talking about the fact that these deaths are not just historic but they're current is for me kind of illustrates the systemic problem that exists.
And so is it your fear that lessons are simply not being learned despite all the recommendations and reviews and inquiries?
Absolutely.
And so although individual initiatives such as the 60 seconds video are very positive and welcome, the key then, if I can sum up what you've said, is there must be following through on the recommendations, monitoring the recommendations, and actually seeing change implemented on the ground.
Yeah, and holding people to account for that, and that that is not just about individual officers. This is also about senior management, because, ultimately, they are accountable for making sure that their organisations are, acting on potentially life-saving recommendations. And it's not like the warnings aren't out there about the risks of restraint. And I mean, I think we are definitely at a place where everybody is aware that restraint in and of itself can be fatal.
Thank you. Could you give me a moment, please?
Yes.
Thank you very much. I have no further questions.
Thank you.
Are there any Rule 9 applications? Ms Coles, thank you very much for coming to give evidence to the inquiry. I'm very grateful for the time you've taken in preparing for that in addition. We're going to adjourn now and you'll then be free to go.
Okay.
The inquiry will adjourn until tomorrow at 10 o'clock.